The seller of the house told the buyer that there was no termites activity in the house. The written contract didn't contain any similar statement. The buyer later discovered that the house was damaged by termites and sued the seller. When the buyer asked the house seller if the house was affected by termites before signing a contract to purchase the house seller then told the buyer that the house was free from termites and led the buyer in signing the contract. Few months later, the house owner found out that the house was affected by termites and had to pay the threat and repair the house. This made the house owner take up legal action against the house seller. The issue of this case is the seller's verbal assurance of the house being free from termites considered a term of contract even though it was not written in the document. Hence, the house owner successfully sued the seller for false allegation and breach of contract. The owner was also eligible to claim for damages. The evidence was admissible about the verbal statement because the written contract was not complete record of the agreement. So buyer can sue the seller of false information of the contract. The rule of this case is the express terms of contract of employment are those specifically agreed between the parties, whether verbally or in writing. If the contract has been reduced to writing, the general rule is that the terms of the contract are to be found in the writing. A contract must contain all the essential terms if it is not failed for uncertainty. The court will not fashion an agreement for the parties where they have not agreed upon essential terms, not agreed upon a mechanism for determining those terms. In this case, the seller of the house intends to sell the buyer and convince to him as there is no problem with the house. The seller verbally expressed to the buyer that the house is clean and there is no damage in the house. The buyer was convinced with the statement expressed by the seller and intends to buy. It escalated quickly and buyer was asked to sign the contract. Unfortunately, buyer have no idea about the presence of termites, and if this information was known to the buyer might have not bought the house as significantly as they had been bought. After a few months, the buyer started to experience that his premises were covered with all termites. The seller manipulated the buyer and gave the purchaser invalid information of the house. The buyer later discovered and had to pay the certain amount of money to destroy the termites, and it also affected timbers after several months. The buyer sued the seller for the cost of repair and extension. By discussion of this case, the buyer action succeeded. The seller's verbal assurance was a term of contract, although there were no termites in the written document. By the way, if the buyer asked to sign the contract and then the problem just came out, at the time the buyer cannot sue the seller for the dishonest. This is because before you sign, you can ask all the questions before you buy a house. So in conclusion, the seller must pay the damage caused since the contract has been breached by the seller by expressing the false information for the buyer, which leads the buyer to sign a contract. When the buyer asked the seller about the termites, seller said there are no termites in the house, but after a few months the purchaser had to face all the damages, and so the buyer sued the seller for representing false statements, and the buyer won the case, and the seller had to pay the consequences. If the seller mentioned about the termites in the written contract, then the buyer would have not purchased the house. So based on the scenario, the seller must pay the price for providing invalid contract.